Welcome back. Well, now that you have the necessary documents, I mean the text of the Hague Convention and the applicability, please note that the Hague Convention of 1965 for International Judicial Assistance and Cooperation has two different methods, two different systems to serve documents abroad. One method, widely known, but a little misunderstood, is the method that uses the central authority. Central authority is nothing else, nothing more than governments, the judicial branch of governments in the different countries. In principle, this system of service of process through the use of a central authority, it's free. But unfortunately, in many, many countries, you will have to pay for the service. And you will have to pay for not only the process forwarding company, but you will also have to pay for the judicial officer that is going to be delivering those documents abroad. It is mandatory when you use the central authority, it is an obligation of yours to have the documents translated into the language of the country where the documents are going to be served. Well, this is very interesting because if the person that is going to receive the documents speaks English, you still have to translate the documents. And translations have to be done properly, because if you do translations that are not properly done, that it's not done by a certified translator or someone that it's have been approved by a foreign affairs department, you're risking not only that your service of process will be quashed, but you're risking also that in the moment when you're going to enforce that court order in the foreign jurisdiction, that those documents are not accepted and the service is refused. Then you have a cost for a judicial officer, a cost for the process forwarding company, you have a cost for the translation, but to that you have to add that service through the central authority. It's a method that is slow, it's a method that is exposed to reject, since the central authority, and when you translate those documents, that's the main objective, is the central authority, it's going to examine your documents to see if you have documents that are civil or commercial. You cannot serve through the Hague Convention of 1965 documents that are related with criminal cases. And as you know, in some jurisdictions, in some countries, what is civil can be criminal. In others, it happens often with author rights, etc. Then, when you consider that you're serving documents abroad by the use of the central authority, you have to understand that the central authority has no time and has no budget. They don't have the means to do research about the person, about the defendant you want to serve, either a corporation or an individual. In other words, it is also mandatory that when you send your documents to the central authority, that those documents are addressed properly. Is it an individual? It must be the address of their national identity card. Is it a corporation? It must be the registered mercantile address of that corporation. Cannot be a place of business. Cannot be anywhere. It has to be the mercantile address of that corporation. On the other hand, serving that corporation can only be, service can only be completed to officials or to persons that are qualified to receive service of process. I'm talking about either a registered agent, I'm talking about their attorney, I'm talking about their legal department, I'm talking about officials that are registered in the mercantile register as such. Definitely, even though it sounds like a joke, you cannot serve the gardener. And that's the way it happens. Then, when using the central authority, you do need to set the correct address. The central authority also has a little bit of difficulties in the sense that it will give the choice to defendant to refuse the documents. A defendant can not only refuse the documents, but he can hide from being served. This is a very, very big problem because the documents will not be served, the documents will not arrive to their destination simply because the person doesn't want to. What happens is that the procedure that are used mostly by judicial officers is simply slipping a little note under the door of the defendant, either a corporation, either an individual, telling them, go to my office and pick up the documents. They have no time to dedicate to this. So this is another little problem, is that your service of process will depend entirely on the will of the defendant to receive the documents. So how will you do that? Once you have your translations, once you have purchased your money order in euros to pay the judicial officer abroad, once you have paid the process forwarding company, how do you operate? It's very simple. You go to the website of the Hague Convention and you look for the central authority of the different countries. And simply you send the documents to the central authority. You can send them by anywhere, any means to the central authority. You can send them by fax, you can send them by internet, you can send them by mail, anywhere. But of course, when the documents are going from the central authority to the person, to the defendant, it has to be done under a certain procedure. And in the case of Southern European countries, that procedure, of course, varies according to country. And when it's done through the central authority, are fairly complicated and are fairly slow. Jurisdictions in Europe, unfortunately, are slow. They are a little congested because of the amount of cases. And judicial officers working this way, they do not charge a fee controlled by the market value, but imposed by the government. Unfortunately, it means that they won't pay as much attention to a file or to another file. They don't care if it comes from abroad or not. They're going to be paid the same thing, and they are paid sometimes peanuts. So, central authority, it's a system that I do not recommend. There's another system, another method to serve documents abroad. This other method is contemplated in Article 10 of the Hague Convention. It has the same hierarchy, the same value as the central authority method. Unfortunately, often it's have been called alternative, even though it's not alternative, have been called subsidiarily, even though it's not subsidiary, have been called also emergency service. It is definitely an alternative to the central authority. It's not subsidiarily to the central authority, but it is often an emergency service from the central authority. And it's an emergency service because once a person has entered into the procedure to serve documents through the use of the central authority sometimes takes a lot of time, not only to serve, but to return the documents. And as you know, courts often give only a certain date, a deadline for bringing back that service of process. So we call it emergency, or they call it emergency often because once they have paid that money for the translation, they have paid money for the judicial officer, they have run into a lot of expenses, they have 1 week left before the deadline, and they have to contact a private service provider like us to, in this emergency, to serve the documents immediately. So definitely, a system we propose, you go for sure from the first moment, and you're not bouncing and doing things.